Josh, thanks so much for joining me today.
Thanks for having me back. I appreciate it.
Well, we're talking about the bail reform in a recent report you and your organization dug into, and it's showing some disproportionality. Can you explain the overview of what this report shows?
Sure. We found two things that existed really in Kentucky's bail system. First, a disproportionate impact on the poor and a disproportionately positive impact on individuals who commit very serious offenses but have the means to post bail.
So given that, let's first, before we get into the nitty-gritty of it, kind of do a rewind and explain why we have bail in the first place, and why bail was enacted as a system in our judicial system overall.
Yeah, essentially the idea is to minimally intrude on the liberty of an individual to ensure their appearance for all court proceedings and to ensure that they don't commit additional offenses while pending trial. Mm-hmm. And so as a result of that, money really became a way for someone to have skin in the game, so to speak. But over time, what we found in this report and what other researchers have found is that having a means-centered system really disproportionately impacts the poor, because it may be a non-serious offense with a $250 bail, but if you don't have $250 that you can pay your bail with, you find yourself sitting in a jail awaiting trial.
And this is a national problem, but here in Kentucky as well, we're essentially setting up a system of debtors' prisons, if you will, mm-hmm. for those that can't pay those fees. And as you were explaining earlier, some of those folks that are violent offenders are getting back out and potentially reoffending.
Yeah, this is the problem with a means-based system, is if you have the ability to pay your bail, whatever that bail is, then you can be released. And if you don't have the money to pay that bail, no matter what your bail is, then you're going to sit in jail while you're awaiting trial. And so we have just under 50 violent or sexual offenders in 2016 who were assessed as high risk with the pretrial risk assessment tool, who were able to post bail and find themselves back out on the street. Here in Louisville, we have between 20 and 30 at any time homicide defendants who are released on home incarceration because of overcrowding issues in our county jails. Meanwhile, we have thousands and thousands of nonviolent, non-sexual, lower moderate risk individuals who have nominal bails sitting in our county jails awaiting trial, costing the state a ton of money simply because they can't afford that nominal bail.
I think it was something in the report that said something like 64,000 nonviolent offenders in Kentucky serving time, and the amount of time that they're serving is kind of astounding, mm-hmm. given those issues of overcrowding. Yep. And you do see that disparity, talking about 43 high risk mm-hmm. or sexual offenders mm-hmm. that are being released on home incarceration. And we know from watching some local news programs, those people are going out and in some cases ending up reoffending for another homicide. Or I think there was one instance that we were hearing about where there was a rival gang knew that person was out on bail and shot up the car. It turns out it wasn't that person, but these are the instances that we're seeing.
Absolutely. We are sending all the wrong messages with our criminal justice system, or particularly with our bail system here. We are burning both ends of the candle, and if we don't reform it in some meaningful way with the recommendations that we have in the report, we can expect to see the candle disappear.
So let's talk about some of those policy recommendations. Mm-hmm. Currently you're talking about we're under more or less a means testing type of a system to determine whether or not somebody's out on bail, and obviously there's some judicial oversight in that. But there's already a tool, the way that I understand through this report, that judges have here in Kentucky, but you're saying that not a lot of these judges actually use that tool.
Yeah, so they're all presented with the information from the tool. The issue is whether or not they sort of accept what the tool says an individual's risk is. And so the prime recommendation is that we move from a means-based system to an offense and offender-based system. Mm-hmm. So who you are as an individual, your criminal history, your likelihood of appearing for past criminal proceedings, things like that, and then the charged offense will dictate what your bail is. And we move away from money so that a nonviolent, non-sexual, low-risk offender can have meaningful conditions but minimal conditions, things like stayaways or no contacts from property or individuals, GPS monitoring if necessary, but so that if they can't afford $250, they don't have to post that $250. On the reverse side of that, we would allow for greater detention hearings for violent and sexual offenders who, regardless of their means, couldn't post a bail if they pose a threat to society, or there's a likelihood that they'll abscond or not return for proceedings.
Got to be honest, it's kind of mind-boggling that these things aren't in place. I know in the report there was an instance of an individual who was arrested for public intoxication, spent weeks behind bars. Meanwhile, you talk about some of these other folks that are homicide offenders that are right back out on the streets.
Yeah.
But what are some of the other things? And as somebody who covers a lot of Frankfurt issues, I hear a lot from the Judiciary Committee, from lawyers that are serving on that panel and are also lawmakers that have some concerns about mandatory actions that judges must take. A lot of folks want to see judicial oversight in whatever system we have. So how does that fit into this larger puzzle that we're looking at here as well?
Yeah, so in both of the recommendations, the move to an offense-based system and the elimination of home incarceration for homicide defendants, we build in a little bit of wiggle room in the recommendations. And so for the moving from the means-based to the offense-based system, we remove money from the equation, but there are still a myriad of conditions that a judge can impose, and there's that ultimate ability to detain violent and sexual offenders. And so we want judges to be interacting with these individuals, to hear from victims, to hear from the prosecuting attorney and the defense attorney, so they can make a meaningful recommendation about, or they can make a meaningful ruling, on what the bail ought to be. But we're just removing money from that equation, but there's still quite a bit of wiggle room. As it relates to homicide cases and HIP, the default should be that home incarceration is an inappropriate pre-sentencing tool for homicide cases. And then if a judge feels that the particular facts of a case, there are legitimate issues of initial aggressor, self-defense, things like that, then a judge could make a finding that the individual defendant doesn't pose a risk to the public at large, witnesses in the case, things like that, and then put that person on home incarceration. But the default should be that it's an inappropriate tool pre-trial for homicide cases.
And there's a fiscal component to all of this as well, and we're spending a lot of money to lock people up as it is.
Yeah, absolutely. Using that 109 days number that you referenced earlier and the $31 a day per diem number that the Department of Corrections pays county jails to house convicted felons, times the total number of individuals that this fits with, we're spending over $150 million a year to incarcerate low-risk, non-violent, non-sexual offenders, low and moderate risk individuals ahead of trial, having been convicted of no crime. And we're creating this giant overcrowding problem where you have these 20 to 30 individuals at any given time who are homicide defendants released on HIP to alleviate some of this overcrowding. But balancing our overcrowding issues or our fiscal issues on the back of homicide defendants is sort of a really backwards way to do it. So we can make meaningful reforms that save money, that protect public safety, not only at the level that we have now, but truly better than we have right now.
There was another interesting component in all of this, and that was a look at recidivism rates, those people that go out and reoffend, especially from the low-level offenses after you've put them in jail versus the people who are getting right back out of jail. What did you find there? So
there's been a bit of research done on low and moderate risk offenders who commit nonviolent, non-sexual offenses again, who are detained pretrial versus similarly situated defendants who are not detained pretrial. And so for the longer amount of time that those individuals are detained pretrial versus the control group who is not detained pretrial, they actually recidivate at a higher rate. It's unclear exactly why that is from the research, but the theory that I have is that most of these individuals are people who aren't career criminals, have not made crime a way of life, and sort of flip-flop in between civil society and criminality. And one of the things that really grounds them in civil society is a job. And if you find yourself incarcerated for a week, 2 weeks, even a couple of days, chances are you're going to lose that job while you're being detained ahead of your trial. And so you lose one of the things that grounds you in civil society, and so you're more likely to recidivate.
Well, that makes sense. Well, walk me through as kind of a wrap up the next steps here. Is this something that Frankfurt politicians should look at, or is this something for local level folks and law enforcement to consider, or where do we go from here?
Ideally, it would be legislation in Frankfurt that changes both the HIP rules and that changes the bail structure overall. It would have to be Frankfurt for the bail structure overall. And judicial discretion in these matters is derived from state Supreme Court rules and legislation, and so the legislature has the ability to change those tools, take away and add tools as they see fit.
All right. Well, we'll see what happens in the upcoming session. Josh, thanks so much for your time.
Thanks for having me.